What is Corporate Ethics Part 2? The Age Discrimination in Employment Act, ADEA, of 1967, amended in 1986, is a U.S. federal law that prohibits discrimination in employment against individuals who are at least 40 years old. It was enacted by the Congress to promote the employment of older people based on their ability and to prevent intentional and non-intentional forms of age discrimination. The Act applies to private, public, and foreign companies with more than 20 workers located in the United States, as well as to unions and employment agencies. The ADEA makes it unlawful to discriminate against a person because of his or her age with respect to any term, condition, or privilege of employment. That prohibition applies to such things as hiring, firing, job assignments, promotions, training opportunities, discipline, and employee compensation. The ADEA covers individuals age 40 and above. A worker who is 39 years old at the time of the alleged discrimination is not entitled to ADEA protection. The ADEA also prohibits employer discrimination among older workers. For example, an employer cannot hire a 50-year-old over a 60-year-old simply because of age. Although the ADEA restricts the use of age by employers, it allows age to be taken into account in some situations. For example, in recognition of the fact that benefits costs may be higher for older workers, the ADEA allows employers to provide different benefits to older legal justification for policies or practices that adversely affect older workers, as discussed in the following section. The disparate treatment theory of age discrimination, or intentional age discrimination, requires plaintiffs, job applicants or employees, to prove that the employer used age as a factor in an employment decision or action. Examples include the refusal to hire older workers based on stereotypes about their limited capabilities and excluding older workers from certain types of training. In cases where it is established that the employer has a policy or practice that treats individuals differently based on age, the employer must prove that the age standard it used is a bona fide occupational qualification, BFOQ, for the job in question to avoid a finding of illegal discrimination. The Refoa Defense is narrowly construed and difficult to establish. The employer must prove that age is directly related to the ability to perform an important aspect of the job that goes to the essence of the employer's business. It is not enough to merely show that younger workers tend to perform better on the job. It must be shown that substantially all persons over the age limit cannot successfully perform the job, or that it is highly impractical to assess the relevant ability on an individual basis.
Age-based BFOQs are most commonly supported in jobs directly involving public transportation or safety, for which there is credible evidence that abilities essential to the job diminish significantly with age. In the more typical case, where there is not an explicit age-based policy or practice and the employer denies that age played any role in the challenged employment action. The plaintiff must make an initial showing of intentional age discrimination using either direct evidence, for example, help-wanted advertising indicating age preferences, disparaging age-related
comments, or circumstantial evidence. To establish a prima facie case of disparate treatment using circumstantial evidence in a refusal to hire case, the plaintiff must show that a. She or he is a member of the protected age class, b. She or he was qualified for the position in question, c. She or he was denied the position, and d. Someone significantly younger, with similar or lesser
qualifications, receive the position she or he was denied. If the plaintiff establishes the foregoing, the employer must rebut the circumstantial evidence of intentional discrimination by producing evidence that it had a legitimate, non-discriminatory explanation for its action, for example, poor job performance, good faith belief that someone else was more qualified. If the employer is able to provide such a reason, then the burden shifts back to the plaintiff to show that the reason offered by the defendant is a pretext for discrimination. Disparate impact age discrimination claims involve employer policies or practices that appear neutral on their face but that have a substantially greater negative impact on older individuals. When put into effect. For example, in several cases, the employer's use of what appeared to be age-neutral physical fitness requirements in hiring decisions were found to have a substantially greater impact in screening out older employees. Even if a plaintiff meets his or her burden of identifying a specific employer policy or practice that adversely affects older workers, the employer may still prevail if it can show that its policy or practice involves a reasonable factor other than age, or Refoa. The Refoa Defense, unique to the idea, requires the employer to demonstrate that there is a good or rational business reason for the employer policy or practice. The Refoa Defense requires a standard of justification that is significantly lower than the Folk Defense, i.e., and Refoa is much easier to establish, and somewhat higher than the legitimate non-discriminatory reason showing that will rebut a circumstantial prima facie case of disparate treatment. Evidence that the challenged policy or practice is related to job performance would be sufficient, but it may not be necessary. For example, in a 2005 ruling, Smith v. City of Jackson, Mississippi, the Supreme Court held that the employer's perceived need to offer junior police officers salaries that were competitive in the job market was in Refoa that justified an employer policy that adversely affected older officers. A range of remedies are potentially available to successful plaintiffs in ADIA cases, including reinstatement to their old job, employment, back pay, front pay, promotion, and court costs. In addition, if it is shown that the employer knew that its actions violated the ADIA or showed reckless disregard for whether its actions violated the Act, then the court has discretion to award liquidated damages equal to double the amount the plaintiff is otherwise owed. Non-compensatory damages, for example, pain and suffering, are not available. Without question, the idea has increased U.S. employers' awareness of and sensitivity to the use of job applicant and employee age in employment decisions. Some provisions of the idea have had a direct and manifest impact on employer practices. For example, the 1986 amendment to the IDEA has eliminated the use of once common age-based mandatory retirement policies for all but a relatively narrow group of employees, high-level executives and employees in selected occupations in which age is a focus. The continued dramatic growth in the number of lawsuits alleging IDEA claims suggests that older workers have also become more aware and less tolerant of age-based employment discrimination. Research investigating the impact of the IDEA suggests that although evidence of differential treatment based on age can still be found in the American workplace, overall, the IDEA has had a positive impact on the employment prospects of older workers. More specifically, empirical evidence indicates that the IDEA helped boost the employment levels of older workers, particularly those aged 60 and over. Questions about moral and political philosophy necessarily entail a consideration of political economy, which comprises two fundamental and overlapping concerns: the relationship between government and business and the relationship between business and society. It is the second relationship that has spawned the notion of corporate social responsibility, which comprises a firm's actions in that regard, or its corporate social performance, and the corporate social orientation of its managers, as well as much scholarship concerned with social issues in management and business and society. With some oversimplification, they can all be distilled into the question: what are the societal responsibilities of businesses? Although answers to this question tend to fall into one of two strongly contrasting models, Archie B. Carroll's taxonomy of the four domains of economic, legal, ethical, and discretionary or philanthropic responsibility provides a more nuanced approach. According to this approach, a firm's economic duty is to operate efficiently and profitably and to maximize shareholder value. It should do so while complying with the law and avoiding harmful civil litigation, as well as acting in accord with societal, business, and industry moral norms and expectations or formal codes of conduct. It should also act to promote the overall welfare of society and avoid doing harm. Partly in response to theoretical criticisms, in recent writings, Carroll has eliminated discretionary philanthropy as a separate category and emphasized the overlapping nature of the three remaining domains. Philanthropy is included within both the ethical domain, as it is often ethically motivated, and the economic domain, because it is sometimes strategically motivated. The two competing views of the proper relationship between business and society are the classical minimalist model of free enterprise capitalism and the revisionist free enterprise framework, in which corporate social responsibility plays a prominent role. Sexual discrimination occurs when individuals are treated differently or receive different outcomes solely because they are men or women. Title VII of the Civil Rights Act of 1964 made sexual discrimination illegal in the American workplace. Specifically, Title VII prohibits discrimination against any employee or applicant for employment because of his or her sex with regard to hiring, termination, promotion, compensation, job training, or any other condition or privilege of employment. Title VII prohibitions also include sexual harassment and pregnancy discrimination. Although Title VII protects both sexes, women are systematically more likely than men to be victims of sexual discrimination. Legally, sexual discrimination is identified as manifesting itself in one of two forms: disparate treatment and disparate impact. Disparate treatment refers to the differential treatment of an individual intentionally and specifically because that individual is a man or a woman. This includes discrimination predicated on assumptions about the abilities, traits, or performance of individuals on the basis of sex. Examples of disparate treatment are asking men and women different questions during a job interview, offering a lower starting salary because the recruit is a woman, or exhibiting reluctance to hire a woman for a job that requires long hours and travel. Disparate impact constitutes a broader definition of gender discrimination and is more complex. Disparate impact results when a particular group is systematically and adversely affected by a company's policy. Although the policy may not have been created with the intent of discrimination, it may nonetheless disproportionately exclude individuals on the basis of sex for reasons that are not job-related. For example, requiring applicants to take a selection test that involves lifting 100 pounds, even though 30 pounds is the maximum a person would need to lift on the job, might unnecessarily screen out qualified female applicants.